Thank you to Thrive Market for partnering with me on today's video. Self-proclaimed First Amendment absolutist Elon Musk is potentially on the brink of buying one of the largest social media platforms in the world. But does Elon's interpretation of the First Amendment actually square with what the amendment and the 250 years of court interpretation of it actually says? And do Elon's free speech ideals create a world and a society that we actually want to live in? Let's do a deep dive into the First Amendment. First, let me thank Thrive Market for partnering with me on today's video. Thrive Market is an online membership-based grocery store on a mission to make healthy living easy and affordable for everyone. You can shop for thousands of the best-selling organic foods and natural products for below traditional retail prices. And if you find a better price somewhere else, they'll match it. They have a wide selection of groceries, snacks, supplements, cleaning supplies, beauty supplies, and so much more. And they have this great feature where you can filter their products by diet and lifestyle. So if you're gluten-free or vegan, you can sort their products so you only see the ones that fit your needs. I really enjoy how vast Thrive Market's products offerings are. I got to try out these new pea-based cheese snacks called 𝗬𝗠𝗎𝗡𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏 to get. And it was all shipped conveniently right to my door. Orders over $49 are shipped for free in carbon neutral shipping from zero waste warehouses. Thrive Market is on a mission to be the world's first climate positive grocery store. Thrive Market has 2 membership options, a monthly option at $9.95 per month and a yearly option for $59.95, which comes out to just $5 a month. For every paid annual membership, Thrive Market donates a free membership to someone in need. Click the link in my description box or go to thrivemarket.com/LeejaMiller to get 30% off your first order and a free gift worth up to $50 when you join Thrive Market today. Thanks, Thrive Market. Okay, so let's start with a breakdown of what the First Amendment says about free speech and how courts have interpreted it. The First Amendment says, in full, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. When we're talking free speech, we are focused on 10 of those words. Congress shall make no law abridging the freedom of speech. That's it. That's all the Constitution says on it. And the brevity of the language presents the first issue that I have with First Amendment absolutism. First Amendment absolutism, when it comes to the freedom of speech, basically means that you believe people should be able to say absolutely anything they want. Their right is absolute and nothing should bar them from being able to express themselves. The problem is that the First Amendment literally only says 10 words about speech. It is intentionally vague, meant to be interpreted by the courts as problems arise, because it would have been impossible to fully encompass all of the complexity of speech protection in that document. So being absolutist about an inherently vague sentence is flawed to begin with. Okay, but then we've had 250 years of Supreme Court precedent interpreting the freedom of speech and what the First Amendment actually means. I'm not going to get into the full history because entire law school classes are taught on this subject alone, but I do want to highlight the exceptions that have been found to the First Amendment, meaning there is speech that the Supreme Court has found is not protected by the First Amendment. It goes beyond free speech and can therefore be censored. And the fact alone that the courts have found there is speech that the First Amendment doesn't protect is another reason against First Amendment absolutism, because even though the First Amendment says Congress shall make no laws abridging the freedom of speech, the Supreme Court has said, yeah, okay, but that's not absolutely always true. There are some times when Congress or the state or state actors can censor people's speech. It's not an absolute right, because absolute rights don't really exist because we live in a society with more than just you. And so your rights can't butt up against another person's rights. Your right to free speech can't butt up against another person's right to be free from bodily or reputational injury, for example. And that's an important distinction here. Free speech is a civil liberty, that is the freedom to do something. Civil liberties often have to contend with civil rights, which are freedoms from something. Freedom from discrimination, for example. That's a civil right. And absolutism about any civil liberty, like free speech, ignores the very real fact that an absolute exercise of a civil liberty frequently infringes on, or at the very least ignores, the civil rights of others. Okay, and here are the types of speech that the Supreme Court has found is not protected by the First Amendment. Inciting imminent lawless action, making or distributing obscene materials, burning draft cards as an anti-war protest, students making obscene speeches at a school-sponsored event, students advocating illegal drug use at a school-sponsored event, defamatory statements that damage a person's reputation, threats like blackmail, threats that make you fear imminent bodily injury, solicitations to commit crimes, perjury, treason, plagiarism, copyright violations. Clearly a list long enough that you should understand that the Supreme Court has, time and again, found that your right to free free speech is very far from absolute. Okay, and Musk has made a name for himself as a First Amendment absolutist, in part by literally declaring himself a First Amendment absolutist, but also by tweeting things like, given that Twitter serves as the de facto public town square, failing to adhere to free speech principles fundamentally undermines democracy. And Starlink has been told by some governments, not Ukraine, to block Russian news sources. We will not do so unless at gunpoint. Sorry to be a free speech absolutist. He also once called someone a pedophile on Twitter, and then that guy sued him for defamation, and Elon won. His lawyers successfully argued that Elon's words, pedo guy, were just heated rhetoric and not statements of fact. He also loves to complain about the SEC investigating him after his tweets have very real consequences in the stock market. Well, as real as consequences can be in the stock market, it's all made up. The stock market is just numbers and conjecture and gambling. Anyway, but despite the fact that Elon really hates having his speech controlled, his actions to curb the speech of others indicate that he actually does have an understanding of the limits of free speech and the potential benefits of limiting speech under certain circumstances, whether he wants to admit it or not. For example, when Tesla, under Elon's leadership, laid off employees, it asked them to sign a separation agreement with a non-disparagement clause that says they can't say anything bad about Tesla in perpetuity forever. There have been many allegations against Tesla of racism, sexism, discrimination, and unsafe working conditions, and many of those same people have alleged that they were retaliated against for speaking up about the problems. The EEOC, which investigates complaints about workplace discrimination, has done a probe of Tesla, and the California Civil Rights Agency has recently filed a lawsuit against the company. Journalists have reported that Elon has asked them to sign NDAs and that Elon himself had to review all articles prior to publication. Tesla asked customers to agree not to post critical social media posts about FSD Beta, an experimental driver assistance software package that they were having Tesla owners test out. They also told users to keep their experiences in the program confidential. The Federal Vehicle Safety Authority, NHTSA, did a probe on the issue because they rely on reports from consumers as an important source of information when evaluating safety defects. And things like NDAs and non-disparagement clauses are typical contract provisions in pretty much any industry, but they do fundamentally curb an individual's right to free speech. And by utilizing these, as well as filing defamation lawsuits and redacting public court filings for privacy concerns, Elon, through his companies and lawyers, is acknowledging that the curbing of free speech can prove to be beneficial or necessary in certain situations. Of course, the question of curbing the free speech of a single employee versus free speech protections for the millions of Twitter users are two very different beasts. And while social media platforms do host the speech of billions of users daily and have allowed for the growth in conversations central to democracy, the fact of the matter is that the internet has created increasingly complex questions about how to regulate social media giants, who should be held liable for speech on the internet, and whose First Amendment rights should be protected or curbed. Because the fact is this: the First Amendment only applies to the state, to government actors. Private companies like Twitter don't have to adhere to the First Amendment. In fact, private companies have their own First Amendment rights, such as the right to create terms of service and to remove content that they don't want on their platforms. And there have been numerous congressional investigations, hearings, committee meetings to discuss how to regulate social media giants, and numerous scholars and lawyers working to dissect internet law and how to balance civil rights with civil liberties when things as huge as global disinformation campaigns threaten to destabilize our democracy. And none of that work has ended in a conclusive answer as to how to regulate social media in an age where it has become the predominant way in which we communicate and get our news. And this is on a scale that far surpasses the print media and the legislation regulating print media that was written before the internet. And despite all this, it seems like Elon thinks he has all the answers. An example of the complexities of regulating the internet, especially through the judicial process, which is filled with judges with no internet expertise, many of whom were appointed before the internet ever existed in the way we know it today, is the legal fight currently happening over a Texas law known as HB 20. Oh yes, old Texas at it again with their absolutely asinine, obtuse bill writing that takes the law and twists it into unrecognizable forms in order to uphold partisan values. We saw it with abortion in SB 8, a law that was unquestionably unconstitutional on its face, but was written in such a way that made it technically impossible to challenge. Now we're seeing an equally absurd law called HB 20 that takes a truly awe-inspiring stance on the First Amendment and was just upheld by the Fifth Circuit, notoriously the most conservative circuit court in the nation. information. HB20 is internet libertarianism taken to its most extreme ends that defies even traditional Republican ideals of small government with limited government intervention into business affairs. It was passed in retaliation against perceived liberal bias of big tech, a bias for which no credible studies have shown any evidence, by the way. Conservatives point to Trump's removal from Twitter as a sign of tech's liberal bias, forgetting that tech platforms remove users every day for far less incendiary speech. Not sure when the last time an errant exposed breast caused a Capitol insurrection, for example. HB20 applies to social media companies with over 50 million users, conveniently narrowing the application of the law to not include favorite right-wing platforms like Parler. The law states that these social media companies can't censor a user's expression on the basis of their viewpoint, and if a company removes a user's content, it must provide them with notice and an opportunity to appeal. And these private victims of viewpoint discrimination can file a lawsuit against social media companies. It also bars companies from labeling posts on their own sites, so those little alerts that pop up that say they contain violence or disinformation, they're not allowed. And it obligates companies to turn over information to the state about the company's algorithms, curation, and account suspension practices. Another provision restricts email service providers' ability to block spam email. Users can sue for $25,000 per day that their email provider impedes the transmission of unsolicited or commercial electronic mail messages. That's right, when Google sifts out that Nigerian prince scam email from your inbox, that is a violation, apparently, of someone's free speech, I guess the Nigerian prince's free speech. So the law simultaneously requires a complete hands-off approach from social media companies from barring or labeling anything on their platforms, while also requiring them to provide notice and a hearing for everything they remove, which is billions of posts a day, and they must turn everything over to the government. What this looks like in practice is requiring each social media platform to overhaul its processes, hire a ton of humans to oversee the review process for removed posts, which is probably impossible given the business model of these platforms. So it will result in social media companies allowing their platforms to be inundated with hate, as opposed to trying to take down posts and go through a lengthy notice and appeal process every time. Neo-Nazi videos? Cool. Russian propaganda? Fine. ISIS recruitment and threats? No. Big deal. Essentially, what this law is trying to do is apply a libertarian interpretation of the First Amendment to private social media companies, but also applying an oddly anti-privacy big government approach in requiring the companies to turn over tons of data to the state. All in an effort to make the internet more open and protect people's right to say anything they want online at the expense of the happiness, well-being, safety, and civil rights of others. So the law was passed, a district court blocked it, saying it wasn't valid because it was a violation of both the First Amendment rights of these internet companies. Republicans love saying that companies are people, but not in this instance, I guess. Another example of how internet regulation is really murky and doesn't easily divide on partisan lines. And there's this pesky law called CDA 230, which I've already made multiple videos on, which protects internet service providers like Twitter and other social media platforms from being held liable for the things that other people post on their websites. So if someone posts revenge porn on Twitter, for example, Twitter can't be held liable for it. And there's a lot of criticisms of CDA 230 because it does protect social media platforms to the detriment of victims of revenge porn, for example. But in this instance, HB 20 flies in the face of CDA 230 and court precedent because it's holding social media companies liable for what it does and does not allow on its platforms. Okay, so after the district court blocked the bill, it was then appealed up to the Fifth Circuit, which last month upheld the law, creating a circuit split on First Amendment rights on the internet that will likely find its way in front of the Supreme Court. What's wild is that during questioning, the judges on the Fifth Circuit showed a shocking lack of understanding of how the internet works. They compared social media companies to common carriers like telephone companies, saying that Verizon and T-Mobile can't bar who you talk to, what you say, and when. They're just a vessel through which your calls are carried. So similarly, social media companies can't regulate speech. The problem is that social media companies aren't seen as common carriers. Court precedent has held them out to be companies that exercise a certain amount of editorialism over the posts they allow or don't allow. They're independent websites, which is different from a common carrier like Verizon. To this argument, one judge, Justice Edith Jones, who was appointed by Ronald Reagan, reminder that Reagan was president 40 years ago, Judge Jones said to the attorney representing the social media platforms, "Your clients are internet providers. They are not websites," which is literally and demonstrably false. Twitter is a website you have to access via a separate internet provider. And it's a shocking misunderstanding of even the most basic workings of the internet that demonstrates just how frail our justice system is when it comes to figuring out how to regulate the internet. And it's really not like lawmakers are any better in their grasp of how the internet works, but that's frankly a video for another day. And then last week, the Supreme Court issued a ruling on HB 20 as part of their shadow docket, and I should probably do a whole separate video about the shadow docket, which sided with the district court, saying that HB 20 should be blocked and not allowed to go into full force force for now. It's just a temporary injunction while the case makes its way through federal court. Basically, the issue is so new and complex that for now, barring it and maintaining the status quo while the courts evaluate it is what the Supreme Court determined to be the best option. So for now, the law is not in force and is stalled going through the federal court system until supposedly it makes its way officially to the Supreme Court for review. And of course, HB 20 is a law that is only enforceable within Texas. But the thing with the internet is that the way it exists in Texas is the way it generally exists everywhere. So generally, websites have to comply with the strictest form of internet regulation out there, and they apply it across the board for everyone. That's why a few years ago, you started seeing notices that the website you're on collects cookies and you have to accept that in order to proceed. That's a product of the GDPR, or General Data Protection Regulation, passed in the EU, as well as the CCPA, or California Consumer Privacy Act, which made California the leader in the US in terms of regulating the internet to promote user privacy. So where I live in the state of Minnesota, websites aren't technically required to make me accept their cookies, but because all of the EU and California require it, websites universally do this in order to avoid liability for these laws. So the same would likely happen with this Texas law, which would basically be a heyday for hate speech and other horrible shit to proliferate on the internet, including speech that is very much not protected by the First Amendment and which very much will infringe on the civil rights of others. And I talk about HB 20 because it gives a glimpse of what could happen if Elon buys Twitter and unleashes his version of First Amendment absolutism on the world. Because Elon's version of the First Amendment, in practice, isn't absolute. It's selective First Amendment protection based on how it serves his personal interests. And there are, of course, very real times in which the Supreme Court has acknowledged that free speech needs to be curbed. But I'm not thrilled about a world in which the arbiter of what speech is and is not free is some kooky, out-of-touch billionaire with a tenuous at best grasp of what the First Amendment and its jurisprudence actually says. There's probably some Elon stans that aren't going to agree with me on this, but let me know in the comments how you're feeling about a potential Elon takeover of Twitter. Are you going to continue to use the platform if the sale does go through? Do you think it's all smoke and mirrors and not much will actually change? Thanks once again to the sponsor of today's video, Thrive Market. Reminder that you can click on the link in my description box or go to thrivemarket.com/Leeja to get 30% off your first order and a free gift worth up to $50 when you join Thrive Market today. Thanks, Thrive Market. If you like this video, you might also like this video where I talk about internet law and the origins of CDA 230. Thanks so much for watching. Have a good day. Bye-bye.